that we need to give this matter all the time, and we agree it is a very important matter. But we have also done research. Supreme Courts all over control their own proceedings and give time allocation. And we have also considered the case that was cited by Senior Counsel Dr. Kaminwa in India, the case, Navande case, which was heard for 69 days. We've also looked at the Supreme Court rulings now of the Supreme Court of India. There is time allocation. That was a long time ago when there was no technology, no written submissions. Now we have written submissions. It's only a matter of highlighting the submissions. So we'll give you the time to do the highlight, and we'll read the record of appeal that is before us and whatever was in the other courts. That said, we will now proceed to hearing by calling the first appellant's case, who has 1 hour, and you can indicate the time that has been donated to you so that it's all put together.
Most obliged, we seek leave to withdraw since we have no room.
Yes, leave granted. Is that the first appellant's case?
My Lady, the Chief Justice and President of the Court, my Lords and my Ladies, good morning. May I begin by thanking you, my Lords and my Ladies, for the opportunity to appear before you and to make these submissions on behalf of the Honorable the Attorney General. And for the record, my name is Kennedy Ogeto, the Solicitor General. And just to confirm, my Lady, my Lords, you have given us an additional 15 minutes. The Speaker of the National Assembly and the Speaker of the Senate had also donated 10 minutes each. So in total, my understanding is that we have 35 minutes in addition to the 45 minutes that we had originally been allocated.
That is correct.
Many thanks. This appeal raises a number of important legal and constitutional matters. But in our view, my Lady and my Lords, these issues principally revolve around two main questions. The first question is, what is the import of our written constitution? And the second question, how much and to what extent can we imply meaning into constitutional provisions that are, in our humble view, otherwise conclusive and unequivocal? Our appeal does not just seek the answers to these questions, it also seeks with equal anxiety the justification for the answers, whatever those answers may be. Our singular desire in this appeal is that the lingering legal and constitutional questions in this appeal be determined and settled by the highest court in our land, not just for today, but also, and perhaps more importantly, for posterity. Through our oral and written submissions, we contend that the learned judges of the Court of Appeal answered important questions the wrong way, and that they had the wrong, often ambiguous, and in some cases contradictory justifications. The first matter I will highlight concerns the applicability of the basic structure doctrine in Kenya. We submit, my ladies and my lords, that the learned judges erred in holding that this doctrine applies in Kenya. At the outset, we have no doubt that our Constitution has a basic structure. No one can deny that all constitutions have some basic structure. We submit that in our case, that basic structure is outlined in Article 255(1) of our Constitution. Our Constitution tells us that it is amendable. It also tells us how it should be amended. It does not impose any limit to its amendability. And yet the learned judges of the Court of Appeal are in agreement, erroneously we submit, with the High Court that the basic structure of the Constitution is amendable only through the primary constituent power, which must include four sequential processes, namely civic education, public participation, constituent assembly debate, and ultimately a referendum. With tremendous respect, we disagree with this position. Neither our Constitution nor its history contemplate the doctrine. We agree with the learned judges of the High Court and the Court of Appeal that Kenya has had a history of indiscriminate constitutional amendments. We, however, note that the people were fully conscious of this while making the new Constitution. Page 73 of the final report of the Constitution of Kenya Review Commission, CKRC, captures this concern, and I quote, "Considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new Constitution from a similar fate?" End of quote. And I underline the words quickly and fundamentally. Authorities at page 173. I have to emphasize, my lords and my ladies, that a plain reading of this report clearly indicates that the problem that was identified during our 2010 constitution making process had two components to it: quick amendments and fundamental amendments. Page 75 of the final CKRC report, a distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being set up for amending the former entrenched provisions. End of quote. This solution is given effect in Chapter 16 provisions, which is the basic structure, is elaborate and onerous. Our humble view is that judicial intervention ought to be limited to confirming that this consciously elaborate and onerous constitutional procedure is strictly observed and followed in amending the Constitution. The learned judges of the Court of Appeal erroneously elevated the basic structure doctrine to a universal template for certain constitutional amendments or change. This fails, my lords and ladies, to recognize that constitutions are not identical. In our humble submission, where a constitution creates an amendment power that is similar to the exercise of the primary constituent power by being inclusive, deliberative, and democratic, such as is the case in our Constitution, the basic structure doctrine has no place. Problematically, my lords and my ladies, the learned judges do not agree on what the basic structure is. In paragraph 474G of its judgment of 13th of May 2021, the High Court had told us that what constitutes the basic structure will be determined on a case-by-case basis. In the Court of Appeal, Lady Justice Nambuye, for instance, states in paragraph 62 of her judgment that the basic structure of the Constitution is, quote, the Constitution itself and what it contains, end of quote. Lady Justice Okwengu, on the other hand, at paragraph 82 of her judgment, expresses the position that, quote, the framers of the Constitution either consciously or unwittingly identified the basic structure of our Constitution through Article 255, end of quote. According to Justice Kiage, at page 85 of his judgment, Article 255 of the Constitution, quote, either coincides or nearly coincides with what may be considered to be the basic structure of our Constitution, end of quote. Finally, Justice Cairo and Justice Tuyot are certain in their respective judgments that Article 255 of the Constitution outlines the basic structure of our Constitution. Even if the basic structure doctrine was applicable in Kenya, which we dispute, the absence of clarity on what the basic structure is would create much legal and constitutional difficulty. This is a matter that we humbly urge this court to clarify with finality. The second issue I wish to highlight relates to the question of the remit of popular initiative in the constitutional amendment power under Article 257 of the Constitution. In our view, the provision does not discriminate as between private citizens and public or state officers. The route is available to registered voters, who obviously include the president and public or state officers. Our study of the history of this provision is that the popular initiative route was meant to curb the monopoly of Parliament on matters constitutional amendments. It was not meant to exclude certain registered voters or citizens because of their positions or standing in society. And here we rely on the final report of the Technical Working Group, K, of the Constitution of Kenya Review Commission on Constitutional Commissions and Amendments to the Constitution, which recorded as follows, and I quote, "The committee introduced a novel idea called popular initiative. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament," end of quote. And that report is available in volume 18 of our bundle of authorities, page 2622, and the quotation will be at page 4 of the report. Again, my lords, my ladies, the learned judges do not agree on the implications of their finding that the president cannot use the popular initiative route to amend the Constitution, or the options available to a president who may wish to spearhead constitutional changes. In paragraph 490 of its judgment, the High Court told us that the president can use the parliamentary initiative route through the Attorney General. Justice Musinga agrees with this position in paragraph 347 of his judgment. Lady Justice Nambuye in paragraph 99 of our judgment and Justice Cairo in paragraph 81 of his judgment agree as much. On his part, Justice Kiage holds in paragraph 109 of his judgment that the president is under duty to obey but not change the Constitution. So according to Justice Kiage, changing the Constitution is tantamount to disobeying the Constitution. Lady Justice Okwengu, Lady Justice Sichale, and Justice Tuyot do not express themselves on these matters. This absence of clarity, my lords and my ladies, is clearly problematic. In addition to the foregoing, the learned judges do not consider the consequence of their finding to a president who, having been elected on the platform of arguably necessary constitutional reforms, finds himself facing a partisan and hostile parliament, perhaps because he has a minority in that parliament, or because he was elected as an independent candidate. Justice Kiage, the only one who expresses his view on this point at page 109 of his judgment, terms this situation as hypothetical. We humbly submit, however, that such situations are a real possibility under our constitutional architecture and therefore require contemplation and an answer which we call upon you, my lords and my ladies, to provide. The third and last question, which I wish to briefly highlight, relates to the question of presidential immunity from civil court proceedings. And here the majority in the Court of Appeal held that civil proceedings can be instituted against the president during his tenure of office in respect of anything done or not done contrary to the Constitution. I wish to highlight two obvious problems with this. First, in order to determine whether the president has done or not done anything contrary to the Constitution, there has to be a judicial process. And this defeats the whole essence of immunity, as the president would have to participate in the process to prove his innocence. Second, immunity from legal process recognizes, as a matter of common sense, that the holder of immunity, in performing his functions, engages in conduct that may expose him or her to legal process. If therefore there was the expectation that the office holder's official conduct must always be perceived as lawful, then the whole question of immunity would be redundant. My lords, my ladies, my other colleagues, acting for the Honorable the Attorney General, shall endeavor to demonstrate to my lords and my ladies additional problems with the findings of the learned judges of the High Court and the Court of Appeal. At this juncture, may I, with your permission, lords, my ladies, invite Senior Counsel George Oraro, followed by Mr. Kamau Karori, to present the arguments, and Mr. Nyamodi will deliver our rejoinder at the end of the proceedings. Many thanks and most obliged.
Thank you, Chief Justice, members of the court. The Constitution of Kenya commences with very powerful words, and that is, we